All right, thank you very much. Mr. Kehoe, all calm and collected?
Yes, and thank you for the indulgence. I think it had its intended effect. We crossed out a few things that I thought we might otherwise need to
Very good, sir.
take up.
Please proceed.
Thank you. I will begin by addressing the scope of the waiver provision and then the enterprise issue that we just heard on rebuttal. We've already, since we went second this morning, have responded in rebuttal to some of the points that we heard first, so I think our session might be a bit more abbreviated. I'll then turn it over to Mr. Weiss, who will respond to what we just heard about with respect to the cure issues. Then Mr. Weiss will turn it over to our partner, Mr. Guillermo Aguilar Alvarez, who wants to raise an issue with respect to the GAMI case that the United States cited in its submission yesterday and to which Peru referred this morning. And then Mr. Burnett will bring us home with the bankruptcy-related issues. Counsel began by stating that the plain language of the waiver supports Peru's argument and is somewhat dispositive, and we can just stop the treaty analysis by just reading the words of the treaty and not interpreting the treaty under the Vienna Convention and the other principles that I reviewed with you. And that's just simply not accurate. The treaty does not say that a claimant gives up its right to have its underlying merits heard in a forum that has jurisdiction over its claims if this tribunal does not have jurisdiction over the claims. So this is a question of interpreting the treaty, which is exactly what I reviewed with the tribunal this morning. Counsel went on to say that there is agreement between the United States and Peru on the scope of the waiver provision. That is absolutely incorrect. The United States did not say in its submission anything of the sort. It did not say in its submission that it is a object and purpose of the waiver provision to encourage resort to local proceedings. And the United States did not say in its submission that a dismissal on jurisdictional grounds would leave a claimant with no forum whatsoever under this treaty. So the statement that there is agreement between the U.S. and Peru on the scope of the waiver provision is inaccurate. Now, with respect to this point about encouraging resort to the local courts, this no U-turn point, Peru did not respond to the fact that, as I pointed out this morning, this treaty has a fork in the road provision, Article 10.18.4, which prevented Renco from bringing a commercial arbitration, for example, under the stock purchase agreement, and then thereafter bringing its claim for an investment agreement to this tribunal. So counsel said we could have pursued our claims in local courts for 3 years, see how they work out, and then bring them here. But that ignores the fundamental basis of what our case is about. We're not challenging a local law that specifically, the way maybe you have in some Argentina cases where there's a revocation of a license or something. A lot of our case depends on a breach of contract action. We have the force majeure provision with respect to the expropriation and the unfair treatment. We have the provisions with respect to the St. Louis litigation. Both of those involve investment agreement components, and we could not bring those claims before a local court or in arbitration. A statement was made today that Renco is arguing that there is an ineffective dispute resolution system if this tribunal is able to dismiss a case on jurisdictional grounds. And that's obviously not what we're saying. What we're saying is there is an ineffective dispute resolution system, as the treaty would be interpreted by Peru, if upon a dismissal by the tribunal on jurisdictional grounds, the claimant was left with no forum for the merits of its dispute to be heard. And I'm going to absolutely get to your question, Mr. Landau, with the hypotheticals from this morning. But, you know, on a higher level, that is what the injustice would be. That is exactly what now Judge Crawford said in Waste Management. An investor would be forgiven for doubting the effectiveness of an international disputes system if, upon being dismissed on jurisdictional grounds, it was then to learn that it couldn't bring its claim in a jurisdiction that had jurisdiction, its merits claim, because of a waiver that it gave to the international forum. And this is a very different issue, and why don't I just go to it now, than dismissal on the merits. And so let me turn, I found the examples during lunch. So some of the examples of this alleged problem with the reservation of rights, and again, we maintain that because the reservation does nothing more than what the treaty allows to begin with, whatever these hypotheticals relate to are hypotheticals that relate to all cases brought under the treaty that are dismissed on jurisdictional grounds. So everything I'm about to say would apply equally if we had that language in the waiver and if we did not have that language in the waiver. And I've explained to you in my opening remarks why that's the case. But just taking the examples. So if we were to have a jurisdictional dismissal of a case for reasons of, for example, illegality, metal-clad with bribery, or the World Duty-Free, I believe it was Kenya case, or the Plama case, or dicta from Lowen, or if the tribunal were to dismiss the investment agreement component of the case because it found that it did not have jurisdiction by definition of investment agreement. These, I think, were the examples. And the answer to that question is, and then I'll be more specific, but the overarching answer to that question is, whatever the answer would be to that question is encompassed within the waiver provision of the treaty. If a claimant has the right, after being dismissed internationally under this treaty for illegality, to bring a claim in a local court that would not be constrained by the same rules that the tribunal found that it was constrained by as to its jurisdiction to hear the claim, which is based on illegality, then the claimant, under the wording of the treaty, without regard to our additional language, we maintain would be allowed to do that. If it has never had its merits case heard, if the tribunal hearing the treaty case found that it could not hear the merits because it had no jurisdiction, there was no agreement to arbitrate the merits because there was no jurisdiction, but there was somewhere where jurisdiction was not precluded by illegality, such that the claimant could try to have its case heard there, then the waiver would not be implicated. Now, other principles would be, whatever the tribunal decided, and this is laid out in waste management, actually, in the res judicata section right at the end of that award. Whatever the tribunal decides on the issue of dismissal is res judicata, and the claimant can't, there's issue estoppel. The claimant is precluded through those legal avenues from trying to relitigate the question of legality and illegality. But that's not the same question as whether or not the claimant can bring its underlying merits, which the tribunal did not hear, to a jurisdiction that might hear it. They might arrive there, and as people have been saying, that court may decide that they won't entertain it, or will or won't. But it does not implicate the waiver. Same thing with the investment agreement. If this tribunal were to decide that there is no investment agreement, as that term is defined by the treaty, such that you cannot hear the investment agreement claims and all claims and measures with respect to that were dismissed, and this is all caveated by what I said earlier about measure. We can't go anywhere if you're keeping a measure. But if the tribunal dismissed the contract claim because of a jurisdictional defect with respect to the term investment agreement, then yes, the claimant can try to bring the merits of the breach of contract claim somewhere else. The treaty, for all the reasons I explained this morning, and which Waste Management 2 laid out clearly, is not designed to deny a claimant the right to have its merits heard, but it absolutely, other principles of international law, and it is res judicata and issue estoppel are principles of international law, would prevent any relitigation of the decision that the tribunal made, and this is laid out in the last 2 pages of Waste Management too. And there is no negotiation. We heard something about, the parties are going to be negotiating what's included or what's not included if this tribunal engages in this treaty interpretation process, and that's just not accurate. Again, what I'm saying is that the language that was added is as though it weren't there. It is superfluous. As I said in one of our briefs, sometimes lawyers do that. They braces and suspenders something for avoidance of doubt. Peru did the same thing. We reserve the right to put on our case on the merits. That doesn't mean that there was any chance they couldn't put on their case on the merits, or that the reservation of rights added or didn't add anything to what they did or didn't have the right to do. So ultimately, the question is, what is the scope of the waiver provision? What can a claimant do who is dismissed on jurisdictional grounds? That will be decided. And does the additional language impact at all what the waiver says? And the answer to all of those questions is no, because if you have not decided something on the merits, nothing in the treaty precludes the claimant from trying to have its day in court somewhere. To the extent that you decide an issue of jurisdiction that implicates facts, well, it's still a jurisdictional issue, but it is now going to be, the claimant is going to be prevented from successfully bringing that anywhere else because of other principles of law. And as I said, this is covered on the last 2 pages of the Waste Management decision. While I am flipping through my pages here, we've heard a number of references to Renco's removal of the cases from state court to federal court in St. Louis as a result of the international arbitration. I'm not sure what the relevance of that is to these proceedings, but we've heard it a few times, so I feel compelled to respond to it. As the tribunal may know, there are 2 types of courts in the U.S., state courts and federal courts. Federal courts hear disputes where there's diversity jurisdiction or where there are questions that have international type implications. State courts are a very different breed of court. And because of the international arbitration and the fact that we have Peruvian citizens suing American companies in the United States over conduct in Peru, and an international arbitration that implicates all of this, a motion was made to the federal court to take the case from state court to federal court, and it was successful, and now the cases are proceeding in federal court. I'm not sure what the relevance of that is to all of this, but I just wanted to explain it to you so that you understand what happened. Now, Renco said, and this was mentioned by both counsel in their rebuttal, that the point was made that Renco said it would withdraw its reservation of rights if Peru agreed to it, and Renco has no authority to ask for that now. The only reason I said that was in response to a statement this morning by Peru that because we have not released and erased that language and stricken it already, it must have an important surreptitious meaning. Otherwise, why wouldn't we have just given it up? Why are we all debating this? And it seems as though our instinct was correct, that if we were to do that now, Peru would then turn around and say, you've now violated the statute of limitations, you've submitted a defective waiver, you can't cure it now. So that is the reason that I raised the statute of limitations issue and the fact that we haven't cured. It's not that we think, as I've said ad nauseum, that the reservation does anything more than the treaty already allows. But if there were not a potential statute of limitations issue, then this issue would have gone away long ago. They just can't have their cake and eat it too. On the enterprise point, counsel argued that the reason that I had argued that the statute was that the treaty was revised in order to take account of what the Pope and Talbot and the UPS tribunals said. And I don't think I said that. If I did, that's certainly not what I meant to say. The point that I was making is that the Pope and Talbot and the UPS tribunals both understood exactly what was going on. And there's a confusion in the NAFTA treaty in that even if an investor is claiming only for its own interests, it has to still submit a waiver for the enterprise. In its reply, Peru states at paragraph 26 that the italicized words above muddied this distinction, and then they went on to say that because it could be interpreted to mean that an investor could claim loss or damage to the enterprise under both Article 116 and 117. So this is the distinction, and it's a confusing point, but what Peru is saying is that a tribunal could get confused and could believe that it could award losses or damages, it could award the investor damages for loss to the enterprise, even under Article 116 when the investor is just claiming for itself. That's what they thought a tribunal could be confused about. And of course, that's not the case. If an investor is not claiming on if an investor is claiming on behalf of the enterprise, the money has to go to the enterprise. Nobody ever thought or argued that if an investor is claiming on behalf of an enterprise, the money can go to the investor. The investor has to claim on its own behalf for the money to go to it. But Peru went on to say, in fact, this was the interpretation adopted by the Pope and Talbot and UPS tribunals. So what Peru is saying is that the Pope and Talbot and UPS tribunals both got it wrong. That's what they're saying. Because according to Peru, those two tribunals interpreted NAFTA 116 and 117 to allow an investor to claim on behalf of an enterprise, but then take the money for itself. And that's not what the UPS and Pope and Talbot tribunals did. They were not confused at all. They understood that when an investor claims for itself, the money goes to itself. When the investor claims for an enterprise, the money goes to the enterprise. They were not confused at all. This article says there's a potential confusion, and she's right, that an investor, a tribunal might get confused if it wasn't an esteemed and good one, and wonder why are we submitting a waiver for an enterprise if the investor is not bringing claims on behalf of the enterprise. Nobody had ever made that mistake. In fact, the tribunals that addressed it said it's sort of immaterial. But in any event, the treaty was changed and this was clarified. But neither one of those cases are inconsistent with our point. And we don't think that either one of those tribunals misunderstood what it was doing when it was interpreting that NAFTA, those two NAFTA provisions. Mr. President, I'm now going to hand it to Mr. Weiss to respond to the cure points that we heard in rebuttal.
Thank you. First, we heard the argument that the text is clear, and at least for purposes of my argument, I submit that misses the point. We're assuming for purposes of my conversation that there is a defect, and the question is whether the defect can be cured. The question is whether the defect can be cured. Second, Peru noted that the United States and Peru agree on certain issues with respect to the question of cure and cited certain rules codified in the Vienna Convention on the interpretation of treaties, specifically subsequent agreements, subsequent practice. I'm not sure that there's any subsequent agreements between Peru and the United States on this point. I do I would probably concede that this may fall under the realm of subsequent practice, but I think it's a moot point. I'm not sure there's that much of a disagreement between the parties. I argued this morning that the views of the United States as well as Peru are entitled to due consideration. My point is simply that those views are not dispositive. To suggest otherwise would be to treat these provisions as if they were self-judging. Third, Peru again noted several cases which have dismissed claims for violations of waiver. We have argued that those cases are distinguishable because they concerned material breaches versus formal defects, and I'm not sure that Peru has ever acknowledged that distinction. We also noted in particular that Peru and the United States have relied on RDC, which drew that precise distinction. There was a reference to Methanex with regards to whether formal defects can be cured. Obviously, I've had limited time, but I did pull out Methanex. It's paragraph 93. And at paragraph 93, there's a settlement between the parties that's recorded, and it states that both sides have maintained their positions, and that as a result, the tribunal sees no reason to make any decision. So I'm not sure that that is legitimate authority for the proposition that one way or the other, whether claimants can cure formal defects over the objection of the respondent. And I think what I said at the end of my argument this morning still stands. No tribunal has ever dismissed a case or a claim as a result of a mere formal defect. Next, Thunderbird, and I would like to take this opportunity to answer the tribunal's question from this morning. It was repeated that there was a debate as to whether timing of the waiver had to be submitted with the notice of arbitration or the particularized statement of claim. If you have our PowerPoint from this morning, specifically slides 34 and 35, on slide 34, you'll see that we are citing and quoting paragraph 117. On slide 35, we are quoting slide 118. I submit these are the two paragraphs addressing this issue, and they should be interpreted together. As you will see in the middle, the tribunal said that because it was purely formal, the failure to meet such requirement cannot suffice to invalidate the submission. So first point, I don't think this is an instance where the tribunal said there was not a breach because the waiver was submitted on time. The tribunal was treating the waiver as if it was submitted late, a year late, in fact, and they said, nevertheless, and I will continue with the reasons, but there was no material breach, and they had provided the waiver, and they were going to treat them as if they had effectively complied, even though, in fact, they had not complied with the technical text. And you'll see on slide 34 my first two reasons. One, formal. Two, not to allow, would be interpreting the treaty in an excessively technical manner. If you turn to slide 35, here you will see the third reason that I suggested to you this morning in construing Article 1121 of the NAFTA, and that's the waiver provision. One must take into account the rationale and purpose of the article. In the second sentence, they repeat the objects and purpose of the waiver that Mr. Kehoe has discussed in detail to prevent parallel proceedings, conflicting outcomes, double redress. And in the final sentence, they note that these entities, which were enterprises of the claimant, had not initiated or continued any remedies in Mexico. And it concludes, therefore, the tribunal considers that Thunderbird has effectively complied. And I would simply submit that the therefore should take into account not only the previous sentence, but all of the reasons in these two paragraphs. So it's not just that you did not commit a material breach, therefore you effectively complied. It's because you did not commit a material breach and you remedied the formal defect. We will treat you as if you effectively complied, even though you did not. There was the suggestion that Thunderbird is distinguishable because it did not concern non-conforming waiver, but instead a question of timing. I believe I addressed that argument this morning. I submit that the defect in Thunderbird was actually worse. 0 rights were waived, whereas here, almost all rights were waived at worst. And certainly, Renco waived all the rights that it believed it had to waive in good faith at the very outset of this case, and has represented that it will waive any other rights this tribunal decides needs to be waived. There was the argument that Renco is incorrect to suggest that in all instances the consent must be perfected when the arbitral proceedings commence, and an effort to distinguish our citations to authorities before the ICJ, before the PCIJ and ICJ. I would quickly note, we cited to that ICJ jurisprudence in our counter memorial. Peru did not address it in the reply. They did not address it this morning. We heard their response to that for the first time. Let me make a couple of quick points. I'll give you 2 examples in which consent can be perfected after the legal proceedings commence under international law. If you go to the ICJ website, it lists 7 forms of consent that a state can give. One of them is forum prorogatum, which by definition is when a state consents to jurisdiction over a claim after the legal proceedings commence. I'll give you a second example. Rule 23 of the UNCT rules. If a respondent fails to raise a valid jurisdictional objection after the statement of claim, it can be deemed to have waived. So imagine the scenario in which a respondent has a valid objection to jurisdiction. There is no agreement to arbitrate when the proceedings commence, but they fail to raise it by the statement of claim. What in that scenario is the basis for consent? It's the conduct, the acts and omissions of the respondent during the course of the arbitration. Again, an example in which consent is perfected after the proceedings commence. And so I come back to Bosnia, the genocide case. There was the suggestion that that case was distinguishable because the Genocide Convention applied to Bosnia, to both parties, when the proceedings were commenced, which was in 1993, but the respondent had argued that there was not jurisdiction because that convention did not comply as between the 2 of them until 1995 at the Dayton Peace Accords. And the point is this: that was the argument of the respondent. And instead of ruling on that on the merits, they said it doesn't matter. Following the Mavromatis principle, this potential defect was resolved during the course of the arbitration. There was an effort to distinguish Mavromatis and a discussion about how that treaty was interpreted to be substantively retroactive. That's true, but that's a different holding. The holding here is that Great Britain had argued that because the instrument creating its consent was not in effect when the proceedings commenced, that case should be dismissed. It's the exact same argument that we're faced with here. And the Permanent Court of International Justice rejected it, and that holding has been repeatedly endorsed by the ICJ for the last 75, 80 years. In conclusion, Peru's authorities are distinguishable. They all concern material breaches, and none concern formal defects, and one of those, RDC, drew that exact distinction. Thunderbird is not distinguishable. It's the authority most on point, and it's consistent with general international law. Renco's interpretation is consistent with the object and purpose of the waiver provision, and there will be no prejudice to Peru if, should you decide it's necessary, you afford Renco an opportunity to cure any formal defect in its waiver. Thank you.
Thank you, sir.
Good afternoon, Mr. Chairman, members of the tribunal. In its submission of yesterday, the U.S. relied on its non-disputing party submission in the case of GAMI versus Mexico. And this is at paragraph 12 and footnote 14 of that submission. Today, Peru also relied on that submission for the proposition that shareholders may assert claims only for injuries to their interests and not for injuries to the enterprise. The record would not be complete if I didn't respectfully draw the tribunal's attention to the GAMI Tribunal's award, which expressly disagrees with this position. And you have that award on your screen. The arbitrators were Paulson, Riesman, and Lacarte. At paragraph 29, you have the tribunal characterizing the position of the U.S., and it refers expressly to the submission relied on by the U.S. yesterday and by Peru this morning. The tribunal says in paragraph 29, the United States, in its written submission before this tribunal, accepts that Article 1116 entitles minority shareholders to bring a claim for loss or damage on their own behalf. It argues, however, that Article 1116 does not reflect an intent to derogate from the rule that shareholders may assert claims only for injuries to their interests and not for injuries to the corporation. The tribunal continues to say it refers to Barcelona Traction as authority for the rule. It cites a U.S. Statement of Administrative Action from 1993 as evidence that at least one of the parties to NAFTA understood Article 1116 to cover only direct injury to an investor, while Article 1117 envisages injury caused to a local corporation owned or controlled by an investor, close quote. This is precisely the argument and the documents that the U.S. presented yesterday and that Peru articulated today. However, in the very next paragraph, the tribunal unanimously disagreed with the U.S. position, and it had this to say: the tribunal, however, does not accept that Barcelona Traction established a rule that must be extended beyond the issue of the right of espousal by diplomatic protection. The ICJ itself accepted in Elsie that U.S. shareholders of an Italian corporate entity could seize the international jurisdiction when seeking to hold Italy liable for alleged violation of the treaty by way of measures imposed on that entity, close quote. And the tribunal delivered a finding in paragraph 33 that is key to your inquiry in this arbitration. The tribunal does not accept that directness for purposes of NAFTA Article 1116 is a matter of form. The fact that a host state does not explicitly interfere with share ownership is not decisive. The issue is rather whether a breach of NAFTA leads with sufficient directness to loss or damage in respect of a given investment. Whether GAM can establish such a prejudice is a matter to be examined on the merits. Uncertainty in this regard is not an obstacle to jurisdiction. And the tribunal went on in paragraph 43 to accept jurisdiction over all of GAMI's claims in this arbitration. Thank you.
All right, thank you, sir.
Okay. Good afternoon, members of the tribunal. I'll definitely try to be brief. Peru says that we have not responded to the...
Do we have the GAMI decision in our book of authorities?
I don't believe that you do, and the reason for that is it was referenced in the United States' submission yesterday. Yeah. So we do not, but we can certainly make it part of the record, and we will after these hearings, if that's acceptable. Thank you.
I would just note, Mr. President, if I might, that with respect to this issue and several other arguments, we, of course, are hearing them for the first time, including answers to questions of the tribunal from this morning. We're considering if there are any implications.
I'm sure that you are, and it's a point we'll come back to once we finish hearing from Mr. Kehoe. We'll have a discussion. Thank you. Please proceed, Mr. Barnett.
Yes. With respect to the local proceedings, Peru says that Renco did not respond to the assertion that there was a waiver violation when Doe Run Peru's waiver was in effect between the filing of the notice of arbitration and the amended notice of arbitration, which is a 4-month period, April through August 2011. Actually, though, the analysis is exactly the same as I previously laid out. The local bankruptcy-related proceedings are clearly defensive in nature. The government itself, in the yesterday's submission, says whether a claimant has initiated or continued a proceeding, as opposed to merely defending a claim, depends on the specific facts and circumstances presented. And I submit that the facts and circumstances presented here make it clear that this is like Occidental, where the investor affirmatively opposed a tax resolution for fear of having it become permanent and binding. Here, too, well before this arbitration started, in July of 19th, 2010, Doe Run Peru was declared in bankruptcy. September 14th, 2010, the ministry, the Peruvian government asserted a $163 million credit. After Doe Run Peru was served with that application, it had 10 days to respond, and so it issued a challenge on November 12, 2010. Within 10 days after that, as another defensive measure, started the amparo on November 22nd, 2010. And I haven't heard anything that has been said thus far that is anything other than form over substance. These are substantively defensive measures taken against a credit asserted against them. And the U.S. government agrees that that is something that would fall outside of the waiver. With respect to, again, assuming that the waiver was in effect, even if it was, Peru seems to ignore the fact that the claims would still stand for the reasons stated in RDC Guatemala, Detroit International Bridge, and actually in the government's submission, because, first of all, the St. Louis-related claims have nothing to do with the measure involved in the local proceedings, which is whether the ministry's credit should be recognized by Indicopy or not. So that clearly is at one side. Then with respect to the remaining claims related to the expropriation, fair and equitable treatment, concerning the pattern of mistreatment of Renco's investment, those are clearly, it's made up of discrete measures of which the issue in the bankruptcy, whether or not the credit should be recognized, is a minuscule part. And so as the government said yesterday, and I quote, "As the Tribunal and Commerce Group observed, the waiver provision permits other or concurrent or parallel proceedings where claims relating to different measures at issue in such proceedings are separate and distinct, and the measures can be teased apart." The RDC did exactly that. It let the fair and equitable treatment claim go forward, but without reference to the measures that remained part of the local proceeding. So the Detroit International Bridge Tribunal said as well, a measure is a discrete act. The fact that multiple discriminatory acts may be part of a common plan does not make them one measure. If a state discriminates against a foreign investor by successively denying a license, imposing a special tax, subsidizing a domestic competitor, these constitute separate measures and need not all be pursued in one forum. So at most, this would be a partial defect, as RDC held, and the claim should go on, but clearly they're defensive in nature and fall outside of the ambit. One final comment is there was some, if I heard correctly, statement that Doe Run Cayman, who is also a creditor in the bankruptcy, their credit has not been challenged. Well, in fact, it has been challenged. I just want to set the record straight. Was Doe Run Cayman credit was challenged. It was as I understand, upheld by the Indicopy Commission and the Indicopy Tribunal, and I understand that those proceedings are still pending. So, thank you very much.
Mr. President, that concludes our rebuttal. With the one caveat, I have not argued it, and I won't now, because based on one of the questions from a tribunal member, I understand that the tribunal understands the circumstances that brought us here on Central Rule 23 and the urgency that was pressed by the respondent in contravention of the procedural order and your ruling, and we do request fees and costs associated with this hearing.
All right. Mr. Hamilton, any response you'd like to make to that last point?
Regarding the last point, as Peru has set forth in its letters and pleadings, it certainly, as the tribunal has ruled, is able to bring this objection. It's a timely raised objection, and Peru considers, if anything, that it is entitled to cost given the violations by Renco. Thank you.
All right. Thank you very much, ladies and gentlemen. I think that brings us near the end of the day. Do either of my colleagues have any substantive questions you'd like to raise with the parties before we move on to final procedures? No? All right, good. Then, thank you. Just a couple of points in closing, if I could. The first one, non-contentious, I hope. Let's start with the easy ones first. As you know, a video recording is being made of these proceedings today, and I would like to ask both parties for your consent to have this video recording put on the ICSID website together with the other materials relating to this case. Mr. Kehoe?
Yes, the claimant's consent. And we didn't discuss any confidential or proprietary information that you mentioned early on,
Exactly.
so we have no reservations with respect to the full transcript.
Thank you very much. Mr. Hamilton?
Peru has no disagreement either.
All right, very good. So, that's a good start. The next point is simply this, post-hearing submissions or any other additional submissions you would like to make. Mr. Hamilton, you've already raised, I think, or signaled that you may want to be providing something more to us, but generally, are you both satisfied that you've been able to make full written submissions to us? Are there things you wish to follow up on? Do you want a full post-hearing submission process, or just something supplemental, if anything at all? Mr. Kehoe, begin with you then, please.
I would propose something supplemental, if at all. I would not suggest, full post-hearing briefing. We've briefed this quite a bit, and you've given us the whole day. I do think that it would be helpful to the extent that there is additional legal authority on any point that we've been discussing today, just because of the speed with which this proceeding took place, the accelerated or expedited, I forget the term that was used, streamlined. But it is possible that there are one or two legal authorities out there that we have not used and that we would like to put into the record without a lot of fanfare, if the tribunal would permit that.
I think we've identified one already, GAMI.
Yes.
But are you proposing just legal authorities or some summary or touching on particular points?
I'm not proposing a summary or anything touching on particular points unless the tribunal has questions or issues that it would like us to touch upon. If it does, then yes, we would very much like that.
All right, well, let's hear from Mr. Hamilton first, please, if we could.
We're also very interested in hearing from the tribunal as to what might be of assistance to it under these circumstances. In any event, to the extent that we were not anticipating new sources, new evidence or new materials at this point of this sub-phase, but if there were any such items, that would have consequences for any proceeding that would be put into place, so that there would not be an element of surprise and that we would be able to address anything perhaps in a second round, and then things become more prolonged.
Then I withdraw that recommendation.
Well, no, I thought I did hear you earlier, Mr. Hamilton, express a concern that there were some issues that had been raised which we hadn't had an opportunity to think about
right.
or to respond to today. And I suppose I'm asking, what are the implications of that statement by you? What are you really looking for?
Give us just a moment, please.
Sure.
Thank you. We would reiterate, and I think share with our colleagues, that we're interested to know whether the tribunal finds that it would be helpful to it to hear further from us on some of these issues, and might be guided by that.
All right, well, how about this then? If the tribunal were to endeavor, say, within the next 10 days or so, to the extent that we have any particular questions that we'd like to have you address, that we come back to you with some of those questions. I don't think they'll be overly burdensome. We've had some very helpful discussions today and very full written submissions previously. But there may be a couple of items that then we would come back to you, say, within the next week or 10 days.
That's very
That's
acceptable to the
acceptable?
claimants, yes.
Mr. Hamilton?
That's acceptable to Peru.
All right, now, in the meantime, you have at least one authority you want
Yes.
to get to us.
Yes.
I hope that's going to be it.
Yeah,
Are
yeah,
you-
that'll be it.
All right, so just the GAMI case you'll be providing to us. Anything from this side?
I would just say, I referenced a few ICSID cases this morning
Yes.
that are not, in the record, so to speak. So if we just go through, for instance, World Duty Free, I don't think it's in the record, but I
Yeah.
can submit, or we can submit those cases if that's helpful to the tribunal. Anything that was mentioned that's not there.
Mr. President, if I may, I did not refer to a case, because it wasn't in the record, that is very helpful for our enterprise argument. And I did not refer to it because it was not in the record. So I would request to be able to put this document in the record, and I'll just tell you what it says right now. If that's what's going to happen, I wouldn't object to what Ms. Menaker is suggesting at all, but I have gotten used to objections to things from Peru, so I withheld this. But I would like to refer to it now in these proceedings and then put it in the record in the exact same process that Peru is going to do.
Just say that the issue with this is, of course, that was in the form of hypotheticals that I was discussing that, but it was done in the morning. They've had 2 times to plead since then, in response, in rebuttal this morning, and then in rebuttal now. But after all pleading is done for him to bring up a new authority and discuss it, of course, we're going to want an opportunity to respond if he's allowed to do that.
I would be
Along-
fine with
if
a
I could-
response, a
if I
verbal
could-
response.
One moment, please. Mr. Keel?
Yeah, I was just going to say, the reason I didn't respond to it is because it wasn't in the record. The hearing today is not yet closed, and I'm now hearing, I didn't realize that the cases that Ms. Menaker had referred to were not in the record. I just learned that, and I'm quite happy. I will give a 2-minute summary of this case, and then Peru is free to respond to it.
2 minutes.
It is the RDC versus Guatemala case. It's the award on the merits. It will be number 132. RDC owned 80% of its enterprise. It asserted a claim for both its own damages and the enterprise damages. The tribunal found a breach, just like TECO, but TECO was 40% owner. The RDC was 80%. And the tribunal found that the claims were absolutely appropriate as a direct investor claim. They found this at paragraph 266. and awarded all of the damages to RDC as an investor through the flow-through method. I'm done with that. Thank you.
All right, thank you. Mr. Hamilton, you're certainly at liberty to come back to us on,
Two
that
comments.
particular
One is, we would take 2 minutes to respond to that, and otherwise would suggest, rather than open Pandora's box here, that the tribunal then take its week or so and come back to us, including if it considers other sources to be of
yes, I
interest
just wanted
to
to
it.
underline the point that it's only those two cases.
Yes.
That's all. So we're closed out on those cases. I think the other ones that you mentioned earlier today, by way of example in the hypotheticals, Madam, would be helpful to have those supplied to us as well.
And so could we just take one moment to respond to what we just heard,
Absolutely.
including the reference to the TICO
The
case,
substance of it, yeah.
which we know very well?
I have an extra copy.
Yeah.
She probably has it memorized,
No, I
Mr.
wanna
Kehoe, so I don't think we need to be detained by that.
Would you like copies? We can-
Thank you. Ms. Menaker, please proceed whenever you're
It would-
ready. I
it
didn't
would
mean to push.
require
I'm sorry.
very quick
You haven't
writing.
read it yet?
No, I don't know. I mean, he stated that they made claims for both their own and Enterprise's damages. I don't know if they made it on their own behalf, on behalf of the Enterprise. He didn't mention. I don't know if, on whose behalf waivers were supplied. I mean, obviously, I need time to refresh my recollection on this case and see what repercussions it has. And, you know, TICO, for the reasons we stated earlier, I mean, is entirely distinct. I mean, they owned, I think it was an economic interest of ultimately 30-something% because it was through another entity, and they were a shareholder in a consortium. They were the minority shareholder in that consortium. They didn't own or control the enterprise. They would not have had the ability to secure a waiver on behalf of that enterprise, nor did they have the ability to direct that enterprise to initiate or continue or discontinue any local proceedings. So obviously they were not under any obligation to give a claim, give a waiver on behalf of that enterprise.
Is there anything more you'd like to say on that point? You said that you would need some time to take a look at that. Does that mean you'd like to have an additional period of time to come back very briefly?
Mr. President, it's difficult to respond to something we've just been
No, I
handed,
fully
obviously,
understand
but
that. I
our
fully understand.
suggestion would be to follow the kind suggestion of the tribunal that I think we've all agreed upon, which is see what the tribunal thinks as it collects its thoughts afterwards. And if we review this and consider there to be a grave issue that we need to address, we would petition accordingly.
That sounds sensible to me, Mr. Kehoe.
It does to me
All
as
right,
well.
very good. Let's proceed in that fashion then. So we'll try to come back to you within the next 7 to 10 days with any issues that we would like to invite you to address specifically. Within the same period of time, you'll get us copies of these various authorities that you'd like to send to us. And if there is any grave issue with respect to that last case, Ms. Manica, your side will certainly be at liberty to address us on that very briefly in a note, and I think that should satisfy everyone. All right? Now,
Thank you.
one other point. Obviously, we have an issue here, an important issue of potentially of jurisdiction, and we have already a procedure in place to continue the arbitration. You'll be very anxious, I'm sure, to know what our decision will be. What we would propose to do is to provide you initially, at least, with our finding. what our decision would be, and then to follow that up later on with the reason. And obviously, that's to facilitate your own planning and work in the next few months. What we have in mind is to come back to you with our findings or decision on the specific issue within 1 month. And then we will follow on, of course, with our partial award, as I expect it would be, on the particular issue thereafter. Is that a procedure which would be acceptable to you, Mr. Kehoe?
Yes, it is, sir.
Mr. Hamilton?
A question,
Yes,
which
sir.
is what implications for the existing briefing schedule? I note that Peru with respect to other pending objections, Peru has a pleading due in the month of September. Our colleagues have one due in the month of
November.
October, November. And then we still have roughly a month before the currently scheduled
Yes, hearing.
hearing in connection with that other objection, should we reach it. And what implication for that schedule?
Yes. Remind me again, if you could, please, the September submission is what date?
The 24th, I believe.
Okay. Can you give us 1 second, please?